Hey y'all, I'm Ada K, and I must confess, I'm a trial junkie. I enjoy viewing trials as if I was the seated juror. So grab a cup of java, get comfy, and join me as we hop into court. And don't forget to comment, like, and most importantly, subscribe. And if you're really enjoying the channel, please join our membership. Well, y'all, more stuff has come out, so we live again. Oh my gosh, I appreciate you guys so much. But we're live again. What else is there to do on a Monday? Oh, I took my earrings off. I took my shoes off. I got comfortable. And then I went live again. So I have we're gonna go over this. We just got posted 11:46 a.m. this morning, and it is the Commonwealth of Massachusetts plaintiff with the Karen Reed defendant supplemental affidavit of David Arienetti in support of defendant's motion to dismiss. So I'm going to bring that on, and then we're going to look at some Hannah Gutierrez stuff. What is that? There it is. My hearing aids aren't picking things up very well right at the moment. So let me share screen, document this at this stage. I'm going to try and embiggen it as much as I can. So let's read this. Are y'all ready? Or should we give a couple minutes for people to hop in? Anybody there? Oh, I didn't tell my mods I was live again. My bad. My mods are going to kill me. They's going to kill me. Oh, well. They don't have to join. We're good. We're good. We good. We can do this. Oh, we got another important thing too. That's new. Oh my gosh. Veronica, you're the bomb. Let me load up the YouTube. Okay, we'll get this done. But I need to move the screen over because I can't see. Put it up with that. Put that there. There we go. Hey, Miss Kevin. I decided to go live with this because it was something that just popped up. And so I thought we'd talk about it. Hi, Thaw. Hi, Sneaky Pants. I know, sneaky side. I call her Sneaky Pants. Hi, Thaw. Well, we've got a document. We got a case that just hit the internet. We've got Hannah Gutierrez. Part of the problem is I was going to save all this till tomorrow, but I'm going to go out of town tomorrow. I got to go see my mama. I have adopted mama that raised me, and then I have another woman I call mama who's my spiritual mama. I'm going to go see the one who raised me. We're going to go visit her, have lunch. She's driving several hours, 2 or 3 hours. I'm driving 3.5 hours, 4 hours. We're going to spend the day with her and then drive home. So, we're Working hard or hardly working? What do you think I'm doing? Yep, yep, yep. If Miss Kevin wants to come on, you can. You don't have to. If Sneaky Side wants to join, you don't have to, but y'all are welcome anytime. So let's go ahead and get started. Supplemental affidavit. I'm going to put it in front of me so I don't have an issue looking at you guys. Can I do that and you still read it? Maybe. I'll just move y'all over there and do this. Oh my gosh, that works. Okay. David R. Yannetti, do hereby dispose to state that the following is true to the best of my knowledge and to my belief. What are you cooking for dinner? I'm hungry, and I just ate a little bit ago. I'm an attorney licensed in Massachusetts since December 1989. That's the year I graduated. You're older than me. My main office address of blah, 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 on July 31st, 24, received an unsolicited phone call from someone who informed me that he or she was a juror to trial in this matter. The caller informed me that his or her full name, which is confirmed with me. Okay, we've already heard this. During that phone conversation, B confirmed me the jury reached an unanimous not guilty verdict. Now, this just hit. Hazak. I saw you at Broken Baker. This just hit. This was just filed today. We knew about that. My phone conversation with B said she confirmed the reach and not guilty verdicts on 1 and 3. He told me the only charge that was that the jury was deadlocked was indictment 2. Juror B told me that she was familiar with the affidavit I previously filed in support of the motion. Juror B confirmed for me that the screenshot of the text message exchange that I referenced in the paragraph 4 of that affidavit was accurate. Specifically, Juror B confirmed that she texted it was not guilty on second degree and is split in half for the second charge. When the judge sent us back that Hernandez thing, it looked at the other side and it turned into a bully match. I thought the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. They gave us free counseling forms when we left, Juror B clarified. However, he or she meant to write, no one thought she hit him on purpose or even knew she hit him. So there's the difference right there. Up here it says, thought that the prosecution didn't prove the case. No one thought she hit him on purpose or even thought she hit him on purpose. That was the mistake. Here is where it was corrected. No one thought she hit him on purpose or even that she knew she had hit him. Juror believes that every member of the jury, if asked, will confirm that the jury reached a not guilty verdict on indictments 1 and 3. Juror believes that the jurors who were leaning towards conviction on some part of indictment 2 will confirm that the other 2 indictments were acquittals. She believes that the jurors have been reluctant to come forward because there is so much public and media attention is focused on this case. Signed on the 4th day of August, ... Wow. What are y'all's thoughts on them apples? That's interesting. That is interesting, y'all. Hey, Zach, how are you? Making breakfast for dinner. Bacon, eggs, and waffle. Oh, my God, Miss Kevin, you just got me going. That sounds so good, and I have eggs here. But I want the waffle part. I ain't got that. So, what's your thoughts on that, Miss Kevin? This is yet another filing. So, do you think that it's possible that they will acquit or drop 1 and 3, and that they will only retry this on count 2? I don't know. Okay, so now we're going to go and watch a video. This is about a Louisiana mayor who did a no. I haven't heard this yet. I just saw I got to talk right. I haven't heard it yet. I just saw the title. Let's watch.
Resigns from office. Then, within days of her resignation, she's booked into jail, accused of raping a minor while she was in office.
It's a very serious crime, and I think that it's important that it be recognized as such.
42-year-old Misty Roberts faces charges of third-degree rape and contributing to the delinquency of juveniles. According to authorities, they began their investigation on July 26th, when the Gutierrez Sheriff's Office requested the Louisiana State Police Special Victims Unit investigate a complaint against the former mayor. Investigators interviewed 2 juveniles, one of which was the alleged victim. Both would confirm Roberts allegedly had sexual intercourse with the young victim while she was mayor.
It seems to be, oddly enough, that when I look at the people that I've evaluated and we look at some of the high profile cases, it's not that this is somebody who is, struggling financially, struggling career-wise, unattractive, unmarried. We tend to find people who are the opposite of that when we look at offenders. And so I don't think it's a matter of this person doesn't know better as much as it is a number of other things that are going on for that person.
A warrant for Roberts' arrest was issued, but she would ultimately turn herself into police.
I think whenever we hear about a female who's been accused of some sexual offense, the immediate reaction is surprise, shock. Unfortunately, all too often disbelief. It's something I've certainly seen in my clinical practice back in those days. And in my forensic practice, I've been involved in evaluating a number of women who were accused of sexual abuse. But I think it is something that we tend to view with really, like I said, just being stunned, because that's not who we think about when we think about somebody who is a sexual abuser.
Forensic psychologist Dr. Joni Johnston says she's evaluated numerous women offenders convicted of sex crimes and explains their motivations for committing the heinous offenses vary.
It's a relatively diverse group, as it is with male sex offenders. So when you look at female offenders, the most common one that we think about is that, okay, some man must have put her up to this. That's typically what people tend to think. And in reality, that's not the case. About a third of women who sexually offend are doing so in collaboration with a male. So either to please the man, to keep the relationship, or as part of a partner dynamics, which means about 2/3 are solo offenders. And of those, we do find kind of a diversity. We have, women who sadly come from a number of generations where, incest and sexual abuse has been a part of their upbringing for a number, for generations. And they oftentimes will abuse their own children. And then we look at who's likely to abuse children outside the home. We see a couple of different, types, if you will. One being the one that we're familiar with is what's kind of colloquially called the teacher lover, the person who is in a caretaking or nurturing role. And they somehow convince themselves they fall in love with this person. And in their mind, they see it as a consensual relationship. There's a kind of a denial that this is a power imbalance. There's no consent when you have a minor and an adult, particularly when you have a teacher or somebody in a position of power. And then you see, more rarely the person who has poor boundaries. They're doing things, for example, like providing alcohol to their son or their daughter and their friends. They're partying. They almost want to see themselves as part of the group. And then something happens along those lines.
But through an attorney, the former public official would deny all the claims against her. In a statement to local station KPLC, Roberts' attorney would say, quote, "It is my honor to represent Misty Roberts. My client learned last night of a warrant despite not being contacted to be interviewed prior to investigators obtaining the warrant. My client maintains her innocence, and as it stands, she is in fact innocent. We trust the public will respect her constitutional presumption of innocence, which is fundamental to our system of justice. Misty and her family are very grateful for the support they have received from their friends and neighbors, and we look forward to putting this unfortunate situation behind them."
I think that the language is always so significant. So obviously in this case, we have an attorney representing a client, and so he has to choose his words very, very carefully. But I think a bigger picture, really, Elizabeth, is that the language that I'm seeing in the media, I think represents
I'm going to pause it there because I don't think we need to get deeper into that right now. OMG. That's a new one.
Where was that from?
That's in Louisiana.
Oh, dear Lord. Ugh.
Mm-mm.
Poor victims.
Yeah, definitely. Lord have mercy. Lord have mercy. Well,
Yeah.
haven't seen you in a while.
Yeah, it's been a while.
How'd you doing?
Thank you. I'm doing pretty well. In the vast expanse of time since I have seen you, I've not gotten anything done. I was going to try and get something done, hopefully, in terms of kitchen, laundry, you know.
And then I go on again. Well, anything about Sarah?
Anything about Sarah? Sorry, Sarah.
Basically, they gave her the evidence. They gave in thumb drives. Then they gave the boxes of all the hard papers to the private investigator, and that court is moving as planned. That's all I know.
Yeah. So I think that they probably were the one thing that they were delighted about in terms of the storm was like, okay, well, at least we do not have to broadcast this. This will not be a live thing. We will not have to worry about anything going wrong.
Miss Kevin says yes. It looks like they had the hearing. The judge approved her investigator, and the next hearing is Friday the 9th. Yep.
Thank you, Miss Kevin.
Yep.
That is interesting. Okay, so what is the investigator going to investigate?
Which investigator?
For Sarah Boone. Like, she put
whatever
him
she
in
wants
the
him to.
suitcase.
I know.
What else is like, I'm just trying to figure out, what is he going to investigate?
I was going to go tacky,
Just
but I'll keep
the DV claim? Or just like, I can't.
House long to. I won't say it. House long. I don't know.
Oh, dear Lord.
To me, it's kind of futile, but going to help her get in touch with the witnesses, I guess. Yeah, there it is, Miss Kevin. Experts, basically a paralegal assistant.
Oh, basically. Okay, thank you, Miss
He's
Kevin.
her leg. He will be her leg.
I need Miss Kevin here to explain things to me. Gotcha.
No, but he'll do all the legwork for her. What she can't do, he does.
Right.
Yeah.
Well, and thankfully, you and Miss Kevin know some of these things, and so you can explain them to me, and then to the other people who don't know these things, they're like, "Oh, okay, so that's what it is." So I am the layman. Yeah,
she'll try to manipulate him as she's done everybody else, and we'll see how long he stays on board. We don't have too many more days till trials. So, well, she's October's. We've got a little time.
Private investigators are usually ex-cops or ex-military, so they have some grit, but I don't know if they'll be able to handle her. She might be worse than a war.
Hey, I know Miss Kevin and Ronnie. They're awesome, and Miss Karen. No. I mean, I think lawyers, they got cojones of steel. Yeah, she's already asked for Miss Kevin.
I don't think she's going to get it.
Said no. when
Mm-mm.
that last hearing that we have a recording where she goes, "Well, I didn't get told, and you couldn't get a hold of me, and this is yet another surprise." I was like, I was like, surprise, surprise.
Woman, I sent you the information to the jail. It is what it is. This is your all fault. You stupid, impatient,
Oh,
narcissistic.
gosh.
I'm totally confused.
Yeah.
Sarah Boone, of course, had 8 attorneys and had them all fired. And then now she's pro se representing herself. And she was pissed in the last court. Did you see the last court appearance? It's short enough I can replay it. But she was not happy with the courts because of the way that they did not. Well, I said Sarah Boone. I didn't say thug. Come on, give me a break. I'm going to have to do it the old school way. Sarah Boone.
So I've had men who have gone to Afghanistan who were like infantry tell me that women, particularly like one woman in particular is like, she was an emotional terrorist and more than I could handle. She was worse than Afghanistan. And I was like, holy crap. And so I was like, I'm sorry if I said a bad word in there. I didn't realize that one of those words might be really bad. The T word might have been. But anyway, so that's what I think about when I think about this woman and the grit of the private investigator, and if that's like an ex-military sort of thing. So yeah,
that's really bad. I mean, it's she's that bad. Here we go. We're going to show this. It's only 18 minutes. If we want, we need. There's people who haven't seen it.
Please, let's
go ahead and watch it. I love it anyway. It's fun.
Dave Cacciatore on behalf of the state.
Ms. Boone, good morning. Could you please raise your right hand so Madam Clerk can swear you in?
Yes.
Ma'am, good morning. Can you state your name and date of birth for the record for me?
Sarah Boone, 10-10-77.
We also have a representative from Prison Break Investigations. Sir, if you could come forward, please. If you could, sir, raise your right hand. Madam Clerk's going to go ahead and swear you in. All right, sir, good morning. Could you state your name for the record?
Billy Lane.
And Mr. Lane, what's your affiliation with Prison Break Investigations?
I'm the owner and chief investigator.
Oh, okay, very good. The reason the court had this hearing this morning is the court has found that Ms. Boone has forfeited.
Okay, I'm going to zoom. I'm just going to get to her complaining.
Copied without violating any terms of the privileges. Those will then be placed on multiple USB drives and provided to you. Those USB drives will then be uploaded to a computer that has been secured for you at the jail for you to access all of that information.
Okay. My question is, was a notice of hearing posted or mailed to anyone to where apparently the news crews obviously got it? How is it that I do not know anything about this other than my bunk being kicked at 3 o'clock in the morning telling me I have court?
Ma'am, I have no other way to get in touch with you other than setting the hearing, which was set yesterday once I received confirmation from the jail as to the processes for how this would work. And I understand that your case is important and I want to move it as efficiently, as diligently as possible. I know that you've been waiting for this information.
I want to get this case out of my files and burn it.
And it took some time to confirm the process with the jail. You've advised me that you have very limited space. You have almost no privacy. You have a small drawer where you can keep some
Hi,
personal
Kelly P.
effects.
Thanks
We
for
could not
joining us.
send all of those boxes with you to the jail, and the jail advised me that they cannot take all those boxes. A process had to be created to make sure, and this is the process.
The process that I was explained after speaking to a couple of sergeants, and I've been waiting for that, and I would much rather prefer a hard copy of these to where I can write on them as opposed to anything that's on a laptop.
I am unable to provide that for you. I have been provided the process has been provided to me by the Orange County Jail. I understand that's your preference, but I can't do anything more than what I've done right now.
I understand. And I have had.
You can what in this hand, and you can shite in this hand. Which is gonna fill it faster?
Had other information given to me, which is why I've been waiting for the boxes for them. So I don't know, is this something that I need to
I got up too early.
pursue continuously still for me to be able to receive my hard copies? Because no one tells me anything.
I cannot answer that question because that may call for me providing you legal advice, which I am prohibited from doing.
Okay, because I have no other way of contacting you other than in a letter, and it's AKA worldwide. So am I supposed to go back and speak to the captain and whoever else it is that I might need to speak to in order to receive these?
Again, I cannot answer that question. All I can tell you is that we will have a hearing on August 5, whereby which Prison Break Investigations will provide all of the information on USB drives. Those will be provided to a representative from the Orange County Jail who will place all that information on a laptop for you to use, and that's accessible for your use from 0800 to 1600 every day.
Right.
Unless I very
Okay,
thankfully die
so-
before then.
I guess I will figure that out, because if I'm up at 2 o'clock in the morning, I can't utilize the laptop, which is another reason why I was looking forward to the hard copy.
No.
So my other question is my time prorated for the time that I've been waiting for my discovery?
No.
I'm not sure I understand what that means.
Will I be having additional time added, or will it be extended from the time period of me waiting for my discovery still?
No.
I'm not in a position to answer that question. I don't know what it is that you're asking for.
My pretrial is supposedly set for September 24th, I believe it is. So obviously I will not be prepared. And obviously I do not know what I'm doing. And obviously I'm still waiting for my discovery. So for that time period that I have been waiting for almost 4 weeks now, will that be added to the time frame in order for me to be properly prepared?
As of right now, the dates are what the dates are, ma'am.
I just missed it.
The dates are what the dates are.
So I also sent you, I believe, 5 motions. Have you received those?
No, ma'am, I have not.
They were mailed last week.
Then I have not received them yet. The last correspondence I got from you, ma'am, was received on July 8th.
Yes, Kelly.
5 motions I've mailed. They're probably sitting wherever else it is, considering it takes a day for you all to receive my mail, considering I'm right down the street from you all. So I have those also in order, which may change whatever information or anything that I'm trying to acquire in between now, the month less that I have in order to prepare for my trial. That's in October. So if you could keep an eye out for those also. I don't know who I'm supposed to ask. How did Mr. Lane come into any of this? Like, how was he called?
Mr. Lane has been your investigator in this case, and he was advised to attend this morning's hearing by virtue of being provided the discovery in order to digitize it so that you can have access to it.
The court contacted him?
I did not contact him.
Am I allowed to speak to him directly?
You can.
Mr. Lane, who contacted you in order for you to be here, please?
JA contacted me.
If I'm pro se and my own attorney, shouldn't I be included in all of this so I know what's going on and not a surprise hearing like it is again for the second time?
Ma'am, again, this is why there were benefits to being represented by counsel. The court has already identified in its 16-page order the reasons for why you no longer have those benefits.
Right.
It makes things exceptionally more difficult, as I explained to you, in communicating with the court and communicating with the state attorney's office.
Isn't that what a certificate of service is for anything that's filed by anybody in the court?
There
That
was,
should be included in that.
ma'am, there was no certificate of service for setting this for today. This was coordinated by the JA. You were advised as soon as it was set yesterday.
It's just very odd to me that the news knew about it before I did.
Again, I can't speak to that.
And so nonetheless, my constitutional right to counsel is being forfeited on your behalf in the court. So now I don't get appropriate notice in preparation for me to be able to be here and doing what I'm supposed to be doing and act as.
When all else
I
fails,
have already addressed
you
the
can't
reasons,
structure.
ma'am, for why there was a forfeiture and alternatively a waiver in the 16-page order that you were provided. Again, it's difficult to communicate with you based on where your current housing is. I'm not able to pick up the phone. The judicial assistant's not able to pick up the phone to communicate with you or send you an email to schedule certain things. And it leaves a little bit of a level of further complication.
How is it the news knows before I do?
You keep asking the same question and the answer is going to be the same. I cannot answer that question for you because I do not know.
Okay, but you do know it's harder for me.
I would agree with that, yes.
And you do know that you did not ask me any questions in regards to your order. You just read it straight off and never asked me what's what or how many with anything of it.
Ma'am, if you have questions, I can certainly try to answer them. I'm trying to facilitate you getting that information that you're certainly entitled to. And it took time for a process to be created by the Orange County Jail, as they had advised me. They do not have a place to store 2 banker's boxes of information, nor are they in a position to provide you physical copies. This is what I've been advised as the process is. As soon as that process was finalized, I set the hearing. This was finalized yesterday.
No one ever asks me. I've been waiting for the boxes. I really don't know what to say, and because I supposedly have no way to contact you other than a letter, and the same for you. I don't know how the news crews got here before I did, but I don't know going forward, how is it that I'm supposed to be able.
Which, please, they got a copy of the court docket.
And so it begins.
It gets good.
able to communicate with you other than me sitting here in front of you at these, I guess, supposed surprise hearings that I'm going to have every single time that it is that you would like to speak to me. Is that what it's going to be?
Ma'am, I cannot answer that question. All I can tell you is that you can communicate with the court through the avenues that you've been utilizing previously by and through letter writing. As I said, I do not have your letters that you sent last week. They're not in the court file, and they were not in my inbox yesterday. So as soon as I receive them, I will diligently review them. And if we have to set a hearing, you'll be properly noticed for it.
In the certificate of service.
You'll be properly noticed for it. Yes, ma'am.
And will there be a proper notice for today?
Notice was performed last night. I've already explained.
Ask the news crews how they got here?
No, ma'am, I'm not going to let you do that. They're not under oath. They're not a party to this action right now.
It's wrong and it's unfair.
You certainly entitled to that opinion.
Am I allowed to ask him a question?
Sure, go ahead.
Mr. Lane, how is it that you and I are supposed to be speaking to one another?
So my suggestion would be, since you're now the attorney and you are pro se, that either you or your honor gives me access to the jail to come visit with you, and I'll be happy to do that. It is the policy of the Orange County Jail to have a letter representing an attorney to allow me to access you. That's the reason for the past previous couple of attorneys have not had the ability to come out and access you, but that's changed. And I'll be happy to continue to move forward with any.
Okay, I think.
I don't know that I'm in a position.
So until you have that letter, you and I will not be able to.
You need to just get a letter from her. She needs to put them on her visitation list. Is the short answer. You just need to put them on your visitation list. It's simple.
Ma'am, do you have any other questions?
I don't think you have enough time. I'm just doing my best. And if you could please keep an eye out for my motions.
I will be on the lookout for them. You said there were 5, correct?
Yes.
I will
If
be
you
on.
could please
Oh,
include me
yeah.
on certificate of service for whatever hearings that we have that are no longer a surprise for me, please.
Understood. You'll be given a copy of the court's order that I read momentarily, and I will see you both on August 5 at 8:45 in the morning. All right. Thank you all very much. Mr. Cacciatore, anything further, sir?
Oh, yeah, she talked to media.
Yes.
Because she's pro se, she can. I don't know what to do with this situation. I'm not being told things appropriately. I lip read. Yep. So, y'all. Oh, didn't mean to do that.
She can talk to the media now that she's pro se because, oh gosh. Well, that's special. I just didn't think that one through. I love true crime, Ada, but I'm new to a lot of this, right? So.
Oh no, we're good. Honey, I only learn by watching other people. I'm not a lawyer, but I'm getting ready to sound like one.
You are very well versed in this, so it's just it's nice to know. Nice to know some information.
Do you know what's funny, y'all? Hi, Momo Shark.
Momo Shark, hey, what's up?
If you don't know, I'm deaf without hearing aids, and I grew up hearing. That's why my speech is so well. But I can lip read when I have a good, clear face shot. Don't ask me to lip read someone like this. However, I am going to school for criminal justice.
Excellent.
But the thing is, a part of me wants to go to law school, but I'm freaking 50. I'll be 55-ish, maybe 56. I don't know, before I could even get in. That's only 10 years away from retirement. I don't know if it's worth that kind of income debt ratio.
One of my good friends, Jackson, he went into law school probably in his, I'm going to say it was his mid-40s. And he was Indigenous, so he was going to go into the Indigenous kind of sector of law. And he ended up dropping out in his first or second year of law school because all he saw was the bureaucracy, and he couldn't unsee it. And even though he spent his life being a public servant and working with like bands and working on reservation and just, yeah, as either like a housing director or public health director, you know, I met him because we were doing the census together. But anyway, he just didn't, he's a really phenomenal person with a great mind. And so I was thinking, this is a perfect person to go into law school and enter this field that does not have enough minds that are needed. And he just disillusioned. He was already very disillusioned, and it disillusioned him even further. So I didn't know that could happen.
Oh, do you know that new intro I made? I got that song off of a copyright-free website.
Mm-hmm.
They're demonetizing it. So I have to, so we're cutting it out of the beginning of the video so I can monetize it.
I will figure it out. I will get you something. You want something like piano based?
Something soft for that, but something that YouTube is not going to flag.
I'll figure it out.
Taking it off so I can get monetized. Do you know the last video is almost at 1,700 views from this morning? 308 watch hours.
From this morning?
I was shocked. Just okay.
No doubt.
Yeah. So
I
I don't
was
want to lose
not
that
aware of that. Didn't
monetization.
know.
Yep. So what we have on deck is the state's response to the defendant Hannah Gutierrez motion for immediate release from detention under 5-402.
Let's see what Bolts has in store for us.
Oh my gosh, it's funny as hell. There's a lot of things I marked in it
Sorry. Excuse me.
because I could not believe the shenanigans, the shade. I mean, she uh,
Oh, does Morrissey come for everyone?
Morrissey's throwing some shade.
Oh, yeah.
She, as my kid says, she gets salty. Why can't I embiggen this more?
Yeah, she
There we go.
is a force.
Okay.
She doesn't throw shade, she throws absolute darkness.
I know. I'm going to bring it in front of me. But I'll need you to handle comments because I can't see them. Oh, quit it. Let me get it where I want. Okay. Are y'all ready? All right. Hear ye, hear ye. Here comes the state. Now the state of New Mexico through special prosecutor Carrie T. Morrissey. I just can't stand her. So the defendant was convicted of voluntary manslaughter. We already know that around. Let me do this. No, we're going to do this after she failed to properly or ever. Okay, shade in the first sentence. Ensured that the dummy ammunition she provided to the Russ was inert. Her competence resulted in 6 live rounds being allowed to float around the set of rust undetected for approximately 2 weeks. Ultimately, she loaded a live round into Alec Baldwin's real prop gun and proceeded to break virtually every rule related to a safe handgun handling by actors on a movie set, resulting in the tragic death of Hannah Hutchinson. Thank you, Braxton. You're on your 3rd out of 4 stores today. Poor baby. You poor thing. I know that's a lot of work going from store to store, but he loves it. The defendant was sentenced to 18 months in the New Mexico Department of Corrections. At her sentencing on April 15th, 2024, after the court became aware of Ms. Gutierrez's shockingly callous and cruel statements made during numerous jail calls to her family and friends, in addition to the statement related to the violation of her conditions of release during trial. She may get in trouble. This here in yellow is something that can really get her in trouble because she broke conditions of release while waiting trial.
Yes.
The defendant initially filed a motion for a new trial and release prior to her sentencing on March 15th of 24 and was denied April 1st. The defendant then filed a motion release pending appeal May 7th, even though the notice of appeal was not filed until May 13th. The state filed its response in opposition on May 27th. The defendant never filed a reply and waited for 2 weeks to file her notice of completion of a brief and still managed not to comply with requirements. Okay. Basically, they're just arguing over when the motions were filed and how things are supposed to work. The package procedure, shall submit to the court a copy of the motion, any response, any reply, any copy of a request for hearing after filing requests with the clerk of court, and the notice hearing form if the party is seeking a hearing. She's just pissed off because they keep filing stuff. Presumably, the defense motion has never been decided by the court or set for a hearing due to the defense counsel all right, listen, the defense counsel's failure to follow LR 1-305. However, the law cited in defendant May 7, 24 motion for release pending appeal is the correct legal standard. So they got a correction. Wah, wah. Nothing big here. So this, once again, she's just sitting here arguing that the defendant's failure to follow a simple procedure. Okay, what? Really? Really? The defendant's failure to follow a simple procedure? Which, please? Who's the one who lost an entire trial by not following basic 101 law procedures?
And got on the stand, even though the judge told her she didn't have to. And even though the defense told her she didn't have to. Like, it was...
that was pride, honey. What happens when...
It was hubris. It was something. It was human nature. Yeah, it was... we saw human nature playing out.
Went back down.
Mm-hmm.
So you're sitting here not following procedures, and you're calling the kettle black. You don't have a right to call it anything. I'm all like, girl, you going there?
Man.
You really going there?
Yeah.
The undersigned counsel is now responding to the defendant's third motion for release since her conviction in March 6th. The motion for release filed on June 17th is the motion for release is in anticipation of a motion for a new trial, meaning you can't sit here and file a motion because you think you're going to get a new trial. And it was not filed until July 16th, and the undersigned counsel will file her response to the motion for a new trial by close of business day, July 31st.
You mean Carrie Morrissey doesn't love...
returns before the court is to file the motion for a new trial. And if the motion is granted, then the issue of the defendant's conditions for release will be ripe for the decision. You're preaching on procedures and how to do things? You're lucky to be walking into any courtroom after that shenanigan BS you pulled. Undersigned counsel is not responsible for a motion for relief pending outcome of the motion of a new trial has not yet even been decided by the courts.
I have a question about Morrissey. Was she or was she not put on a Brady list? Were her and Papa put on a Brady list? I heard that they might have been put on a Brady list.
They may be. I don't have
that there was
but her and everybody involved in that little shenanigan will most likely end up on a Brady list.
I heard that there's a judge report that has a lot of smoke for her and Papa, like a lot. So I haven't read it.
That report. I don't think I've seen it. If we have it, I don't know it.
I'll talk to Ronnie and I will try to go find it, but she's probably more resourceful than I am. However, that's just what I've heard. However, I could be mistaken.
There's so many documents. So, undisclosed Hague report. Okay, y'all, this is the important part. In her June 20, someone asked, and I'm playing on several media formats. I have highlighted these in different colors. Number one, with dyslexia, it makes it easier to read. Number two, each color reminds me of something. So I have a kind of like a plan here. In June 27th of 24, motion for release in anticipation of her motion for new trial, defendant alleged that she has been prejudged by the state failure to provide her and her counsel with copies of 2 reports from the state ballistic expert, Haig. Now, red is Shay. Defense counsel is either initially misleading the court or simply not done his homework with regard to his allegations against the state. Y'all, all the Shay that she's been throwing, pink is sort of Shay. Red is like, the judge isn't going to like this. The judge is already like up to here with her. The judge is definitely not going to like what they're seeing in this for sure. Mr. Haig produced 3 reports. The first was issued on August 2nd of 23 and was timely provided to the defendant. The second report was produced on August 31, 23, and the undersigned counsel believed she had forwarded the report to the defense counsel, but realized during the pretrial work on the Baldwin case that she inadvertently failed to disclose the report. The third-party report was produced on the 5th of October, 23, and was disclosed to the defense counsel and was also uploaded to Discovery for Hannah Gutierrez reads the exhibit. Okay. Y'all. I could care less what you intended. I don't care what you believed. I don't care what you thought. It is your job to know. I believe that it was forwarded. Oh, my bad. Please. That ain't good enough. Either you did or you didn't. It doesn't matter what you believed or what you thought. It doesn't get you out of the hole you're getting in. Well, you haven't dug yourself out of the crater that you've been in, and you're digging another hole inside of it. The state concedes that it failed to disclose the August 31st, 23 report, but disclosed the 5th on 23 report the same day. Who cares? Who cares what other reports you've disclosed? What we want to know is why in the hell did you not disclose the one that you're speaking of? I don't understand. Why are you playing this game? This little game that you're playing, my dear, is just going to piss off the court. The only report by Mr. Haig that was not disclosed was the August 31st, 23 report discussing the tool marks at the top of the sear. The findings of the report are not exculpatory and are not likely to result in a new trial for Ms. Gutierrez. That is not your right to say. That is not your right to disclose. You don't have a right to say that. I clicked off accidentally. Let me get it back up. You don't have a right to any of that information. I mean, to hold any of that. Whether it helps or hurts the defense, it doesn't matter. It's up to you to turn it over, all evidence. It's like the defense has evidence that the state doesn't have. They have to turn over all evidence, good, bad, or indifferent. And if the state had known some of this stuff, I mean, the defense, they may have acted differently. They may have questioned differently. They may have filed things. I mean, there's a whole lot of things they could have done. So for you to sit here and make the decision that, it wouldn't make any difference in the results, and it would, in getting a new trial, it's not going to affect her. That's not for you to decide. Woman, Miss Bowles was
throwing boulders in a glass house.
Huh?
She's throwing boulders in a glass house.
Oh, yeah. Mr. Bowles was actually aware of Mr. Baldwin's claim that the gun discharged absent a trigger pull, and was also acutely aware of Mr. Baldwin's counsel's absurd assertion. Really? More Shay? That the gun was modified by someone, and the unproven modification resulted in the gun going off by itself. It was worth noting that most likely the person would have modified the gun was Miss Gutierrez. Really? State Exhibit 2, Mr. Bowles verbally attacked undersigned counsel. Oh, he called you on your crap?
Oh no.
Poor baby. Poor baby. For dismissing the case against Mr. Baldwin and requesting forensic testing of the gun. Response to Mr. Baldwin's counsel claimed that the gun was modified. When the slight wear and tear in the newest report, not sure what report Bowles is referring to, again, salty much, isn't remotely evidence of modification or anything to do with the trigger function and functionality of the weapon. You have video showing the gun working, cocking and firing on set. The FBI said the gun functioned properly prior to their damaging it. Baldwin had to have pulled the trigger, and you know it. What? Okay. I talked to a friend of mine who builds guns. I asked him about this. I showed him the picture. And he said sometimes a gun that has those kind of markings and wear and tear, or if someone did it purposefully or not, that if you don't have to pull the trigger to make it fire when there is filings or damage. You can do what's called a pressure on the side of the trigger. That when you put pressure on the side of the trigger, see how when I put pressure on my finger, the back of this will move. This part right here flexes out, which can cause it to move just enough for the gun to misfire. We'll never know, but that is a possibility. So it's important to note that Miss Gutierrez hired her own expert, Frankie Cochran. Oh my gosh. This is the guy who put the gun towards the judge's face. And she calls him on it. Listen, the nice man who pointed the gun at the bench during testimony in Miss Gutierrez's trial. Yeah, I said it. I'm like,
I have to agree. I do kind of like that one though.
I know.
Because
he actually
it was just kind of like, what's happening here?
Huh?
There's just crazy that was a crazy courtroom that day. That was an insane expert.
That was cray.
Yeah. Mm-hmm.
Definitely cray. Miss Bowles never took a step to have the gun tested. Mr. Bowles never took a step to have the gun tested or examined by Mr. Cochran. Cocky. EDB calls him cocky. The photo of the previously unexamined, now explained unusual tool marks on the working surface was sear was in the possession of Mr. Bowles and in the duty of providing the photos, yada, 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 yada. So here we go. The image on the right is a weapon that's clean. You see on the left, see how all those little marks, that's not good. Hi, Jedi. Oh, you have a greenhouse. That's so cool. So, Mr. Bowles has misrepresented August 31st report to the court in his motion.
Hi, Karen.
Hi, Karen.
I have my my mic muted because my dogs have been barking too much. So I just want to say I have my mic muted, but I just wanted to say hello to everybody who's watching. Thanks for joining us. But yeah, you can see the difference.
So this on the right hand is from the machine processing. And it says it seems likely, although it cannot be excluded, that these tool markings on the left result from damage occurring during the FBI impact testing because of the axis of the strident is not aligned with the direction of the hammer would have engaged and applied the pressure of the sear. Now, that, the trigger sear do not appear to have the original manufacturer markings. Duh, it's altered. These tool marks also are unlikely to have any bearing on the operation of the revolver at the time of incident. Not necessarily true. Their testing document of lack of malfunction. The Hague report simply noted unusual tool markings, and he concluded to opine the gun worked properly and did not malfunction or fire on its own volition. Yeah, I'm still doing the same. I'm not going to read every word of this, but this is interesting. I would say in retrospect, now this is Morrissey, since I have both the benefit of seeing Mr. Pettis interview as how he makes the firearms, and the interview fairly recently with Boyce Ziegler. Is that it? Ziegler? Where it could clarify how he did his impact testing. I would say my statement back in August was perhaps premature. Really? I still maintain it is obvious damage, not an effort to improve the trigger in some way. It is not something that came in the gun. Okay, y'all, it's going to get a lot. If your mind doesn't stay clean, it's going to get interesting. But what I didn't know was at the time is a history of the gun. So the statement was very neutral. I don't have any further information. Now I do. I've learned that the particular gun was the industry often calls it as a one-off gun. It's a symbol especially for a thing I usually, this is the witnesses. It's for gun shows. Okay. Now she goes down here and says, highly unlikely because of all the professionals, the hammer would still be in the gun at the SHOT Show, but the firing pin would have been removed. And that is true. Zach, am I boring you? I'm sorry. The only other choice that left
us. I didn't see you that you were in here. Sorry.
Huh?
I didn't see that Zach was in here. I wasn't. I just didn't see that Zach was in here. Hi, Zach.
But this gets funny.
Your dog is cute. I saw the dog in your
rawhide mallet. Photo. The gun that was mounted in a fixture and makes perfect sense. I have a similar fixture, but the blows that he gave it was with the rawhide mallet and was not necessary in any sort of apparatus. It would deliver the blow in perfect front and back. Typically, oh no, just oh, yeah. There's Emily B. Baker and other people have gone to the same place, y'all. I'm going to illustrate. So he stands up and illustrates. It's going to apply side force, and it could be right to left or left to right or left to right. And that could and would easily explain not only the damage, but how it got the angular component. So basically, she's saying that all of this stuff about the gun is really irrelevant. What is true? Hague's report stands for the notion that the gun fired by itself or malfunctioned, which it is not. It does not change the fact that the circumstances surrounding Ms. Gutierrez's conduct resulted in her convictions. Now, I wrote true there because in the end, it was her responsibility to ensure the safety of the weapon, and she did load the live round in it, whether it accidentally went off or the hammer was pulled. Doesn't matter. She loaded a live round into it, period. Well, I could go to the half cock, full cock, quarter cock, but I know it all too well, and I'm not going to get into that explanation too many C words, and like Emily said, too many D jokes in the law. She got to laugh. But anyway, so I'm going to skip most of this. It's not as important. But so now what we're talking about is the law governing post-conviction release. She is saying that the court on motion of defendant may establish conditions of release pending appeal or motion for new trial. The defendant shall be detained unless the district court, after hearing, determines that the defendant is not likely to flee, which is questionable in this case, and does not pose a danger to safety of any other person or the community if released. Oh, don't worry about it, Zach. So here's the thing. There's a bunch of things that they look at. One, the nature of the circumstances of the offense charge, including whether the offense is a crime of violence or involved alcohol or drugs. Well, we're not sure about the alcohol or drugs because we don't know what she had in her system. But under that does not apply to her. The weight of the evidence against the defendant, that's iffy. She did load the weapon. That's the weighted evidence, but the rest is still kind of iffy. The history and characteristics of the defendant, including, okay, the defendant's character, physical and mental condition, family ties would be one, employment, past and present residence, the length of residence in the community. Well, that's huge. She doesn't live in the state. And the community ties, she doesn't have any past conduct. She was there for a few months and got in a lot of trouble. History relating to drug and alcohol, yes. Criminal history, yes. And the record about appearance. Okay, so she does have another federal case against her for carrying a firearm in a business that served alcohol, and 51% or more of the revenue came from the sale of alcohol. Whether the time, at the time of the current arrest, the defendant was on probation, no. The nature of serious danger to any person in the community that would put, no, she's not really a physical danger to anyone. The other facts tending to indicate the defendant may or may not likely be to appear as required. That's one, I missed it. And the other facts, so they're claiming that she's a flight risk. So, and there you go. She does not have a right now, while Ms. Gutierrez has no prior felony, she does have another felony case pending in the first judicial court. The history of Ms. Gutierrez's time in Mexico is troubling. I said that. Ms. Gutierrez was only present in New Mexico for less than 4 weeks. 4 weeks. And there's evidence that she committed 3 felony offenses during that time. Ms. Gutierrez has been found guilty of involuntary manslaughter. She has a pending case for carrying a firearm into a liquor establishment, which appears to have been committed with a blatant, flagrant disregard for the law related to public safety. And there is ample evidence that Ms. Gutierrez was in possession of cocaine in New Mexico and handling firearms daily. That's huge. She has a significant substance abuse problems that back nearly 10 years. She has cellular extractions containing evidence of long-term alcohol abuse, cocaine abuse, and the use of physical psychedelic mushrooms, and evidence of huffing from aerosol-type containers. My question, when did all that happen? Was it when she was a minor or an adult? She still did it, but jail calls, previously undiscovered violation of her conditions of release prior and during her trial for alcohol use and abuse of such degree that it appeared to have negatively impaired her physical relationship. Wow. Personal relationships. In 2 jail calls, Ms. Gutierrez discussed consumption of alcohol while on conditions of release, and her boyfriend complained that she mistreated him when she consumed the alcohol. Jail calls indicate clear disdain for the court's order and willingness to refuse to appear in court when ordered. Okay, that goes back to when they were trying to force her to testify in Alec Baldwin's case. Her judge put a motion in, and that's where that came from. In one phone call, Ms. Gutierrez expressed a willingness to refuse to appear in Mr. Baldwin's trial. Yep, if unlawful. Yep, she refused. All of Miss Gutierrez's family members and boyfriends are gun owners, and she expressed the willingness in jail calls to run afoul any court order requiring her to refrain from possessing firearms. One phone call, she discussed with her boyfriend that he could put his guns in the safe and that he could tell them probation authorities that she does not know the combo. The defendant's motion for release is premature given the court has yet to receive completed briefing on the defendant's motion for a new trial. Her arguments on the defendant's motion and ruling on the motions in the defendant's favor. That be all. Wow. What do y'all think about all that? Zach, you've been funny.
Yeah, Zach is funny.
Wow.
Yeah, that is. So do you think that Morrissey has so much snark just because she realizes that everybody's got smoke for her? Like, what is it that she can't not operate with some sort of attitude? Because, like, I get it. She's a badass bee, but, like, what is it? What's because I don't know what possessed her to do that, because she's a smart woman.
I don't know. I mean, she is a very smart woman, and she supposedly was extremely highly regarded as a very, very, very famous, not famous, a very good attorney. However, I think the court is so done with her snark and her saltiness that this is not going to bode well for her. She doesn't like to lose. That's right, Ronnie. But it's, you know the saying, honey? Catch more flies with honey?
Yeah.
And she, I'm breaking up fights. Wait till the teenagers. You just tell them to go outside and hope one survives. But anyway, I just don't understand. Does she not understand the precarious position she's in? Now, I was hoping the judge or somebody would report her to the bar, but they're not going to do it.
I don't understand. It's
a judge for this. It takes a lot for a judge to report a lawyer to the bar. Who knows? She could have, but a report to the bar from a judge. It's like it's like the 4 alarm going off, and they jump on those quickly. Some other attorney, somebody else can just file a report to the bar, and it takes a lot longer for it to get through the process. But I was surprised that she is still being retained as the special prosecutor should anything else happen. I would think that she would be replaced if they could.
Mm-hmm. Yeah, I was very surprised by that.
Not been replaced.
I was so shocked when you said that she hadn't been replaced, because I was, yeah.
Not at all. And I am perplexed as to why she's still there. But then again, maybe that's the best shot for Hannah to get out and try to save herself. But what bothers me is if Hannah gets out, we all know she's guilty, right? She's guilty because she didn't do her job. And everyone is surmising that other people had a plot and all that. Well, that's not her. I don't think. But I just don't want her going back and being an armor in other places. I don't think she should own a firearm. I don't think she should be around firearms. And if there's any chance of her being around one, then she's got to go through serious training and pass tests and maybe limited to a BB pellet gun. You know, I don't know. It just to me is. I hope that she gets a retrial and not just dismissed with prejudice, because that would be devastating, because then she can go right back to what she's doing now. I don't think anybody in the industry is going to hire her, but then again, who knows? You pulled an Ada. She pulled an Ada. So you guys, thanks for joining me. I just wanted to get this read because I was going to do this tomorrow, but I'm going to be out of town tomorrow. Gosh, I drove 5-6 hours yesterday. I'll be driving 7-8 hours tomorrow. So if anything happens, I'll be on the road. I can do a live on the road if I need to, but I will be watching other stuff because I can't say watching. I don't watch it. About the only time I can hear things is either going through the car stereo, Bluetoothing into my hearing aids, or through the Rodecaster into my hearing aids. So when I am on long drives, I listen to as much as I can, although I don't hear every word. I hear a lot. I hear enough to get the concept. So what'd you say, love?
Sorry, the dock that my computer is connected to my monitors to was having a seizure and like unplugging, plugging in, unplugging. And because my mic was connected to the dock, it would unplug every single time. So I apologize. I just unplugged everything and replugged everything.
What's in the box behind you? Shelves?
Pardon?
The box behind you, is it shelving?
The boxes behind me are eventually going to be closet organizers, because this is the closet for my spare bedroom, and this is eventually supposed to be my office as well. It is also holding just random painting crap, and there is
I see that, but I've just been seeing this
is an old store sign. It was called
cool.
Records. That's a black cat. Ooh, right there. Black
That's
cat
cute.
and a record, yeah. So anyway, that's my habitat. That's my habitat. The chaos I am living in.
Who's texted me? Ronnie did. Let me see.
I was about to say, I think she's even sullied her father's name in Hollywood, and it's gotten to the point where people would be hesitant, like they would still want to work with him, but they would be hesitant to try to work with him if she were out of prison, in case he were to try and bring her on board for anything.
Oh, they would probably can't be on set, period.
Yeah.
Well, guys, I have to, it's almost 5:30. I got to get ready to close up. Got to get some paperwork done. But we got this done, so tomorrow I won't be live. If something pops up tonight, I doubt it, but if it does, I will be here. In the meantime, y'all be blessed. I will probably see you Wednesday. We'll be watching everything that happens. And if anything hops in and goes crazy, well, we'll be here one way or the other, as my friend used to say. Blessings.
Right.
Thanks for joining.
Drive safe, Ada, tomorrow. Bye.
Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.